So the book is now out, and 6 months after Virginia Giuffre's death, A Nobody's Girl lands with the weight of a judgment. It's a 400-page diary-style account of grooming, trafficking and alleged abuse, and it arrives with a very specific charge sheet of power. The book is published today, and this book poses three questions that cannot be ducked. First, what do Giuffre's allegations add to the record about Jeffrey Epstein and Ghislaine Maxwell? Second, what do they add about Prince Andrew? And third, what should public institutions do when private wrongdoing corrodes public trust? Giuffre recounts years of manipulation by Epstein and Maxwell, describing violence, sadism, being trafficked to scores of wealthy, powerful people. She writes that she feared she might die a sex slave. These are not new themes, but the detail and the tone are new, and they're meant to force a reckoning, not to titillate a headline. On the record, as before, are three alleged encounters with Prince Andrew in 2001 to 2002, first in London, later in New York, and on Epstein's private island in the US Virgin Islands. Andrew denies all wrongdoing and says he has no recollection of meeting her. The memoir repeats the familiar motifs: Trump's nightclub, the photograph in Maxwell's Muse house, the sweat dispute, but adds texture, such as Giuffre's claim that Maxwell told her she was to meet a handsome prince and that Epstein paid her $15,000 after the London encounter. The book also alleges that Andrew's team tried to hire internet trolls to hassle her during litigation, and that he stayed behind Balmoral's gates to avoid service of US court papers, claims that, if true, speak to strategy as much as morality. Again, Andrew denies wrongdoing. Two anchors matter. First, the 2019 Newsnight interview where Andrew said he had no recollection of meeting Giuffre and floated the Pizza Express alibi and a medical explanation for not sweating. Whatever his intention, the interview functioned as evidential oxygen for civil lawyers, reputational nitrogen for everyone else. He looked a fool, in other words. Second, the 2022 settlement. Andrew paid an undisclosed sum to conclude Giuffre's civil claim without admission of liability. The agreed statement acknowledged her suffering and reported at the time suggested a large figure, although the amount remains confidential. Now, add this month's development. Andrew has given up using his titles after days of political and media pressure. Ministers have called it the right course of action, while some MPs push for legislation to remove titles formally. Whatever the constitutional niceties, the optics are plain. Public privilege bends under private gravity. What's new about her book? Well, there are three things that stand out. First, Andrew is referenced 88 times across 400 pages. That density matters in public understanding, even where legal standards are unchanged. Secondly, the tactics, the trolling allegation, if substantiated, would reframe the dispute from he said, she said towards the ethics of reputational management in abuse cases. It's a claim worth serious scrutiny. Thirdly, the institutional appetite for accountability. The Met Police has said it's looking at related claims. Parliamentarians are now debating whether and how titles should be removed by statute in similar cases. One may disagree about remedies, but the constitutional question is unavoidable. How should a modern state respond when the court of public reason gets there before a court of law? And the uncomfortable truth of who knew what. It's tempting to say Andrew has stepped back, title set aside, case settled, draw a line. The memoir contests that narrative. It insists there's no clean line because the harm is not linear. It ripples through victims, through public institutions, through the monarchy itself. The palace can say it doesn't act for a non-working royal. Voters can say that non-working royals still affect the working monarchy. Both statements are true, and both are insufficient. The real problem, the real damage will be if a senior member of the royal family or the royal entourage knew about Prince Andrew and what they knew and when. Giuffre's bluntest sentence about Andrew is also the most revealing, that he seemed to believe having sex with me was his birthright. You may reject that claim, you may say it's impossible to adjudicate years later, but the allegation forces a moral audit of entitlement, consent, and the culture that insinuated and insulated Epstein's circle. The book is not just a memoir. It functions as a mirror held to a system that let a convicted offender retain social cachet long after his Florida conviction. For scholars and journalists, the task is simple but not easy. Separate allegation from proof. Note where claims align with contemporaneous records. Treat the book as testimony, not verdict. Remember that Andrew's position remains a blanket denial that he settled without admission, and that the British and US authorities will act, if they act, on law, not outrage, not tittle-tattle. The problem with Prince Andrew really is this question of proof that he did certain things, or proof that he is a certain character. Now, what Giuffre's book does is to establish almost beyond doubt that he is a certain character. To then move on from that to did he do things is another matter. And this goes back to the principle established by Bentham about character. Is it mens rea? I think it is. And why does one do something? Why does one act? Andrew's character is shredded in this book. And there is, I think at the end of it, no doubt at all what his character is. Now, we may have speculated beforehand. Here we've got 88 references that chip and chip and chip and chip and chip at any idea that Andrew's character is worthy, that he is good. Axios. 3 imperatives follow: process, transparency, and support. Abuse litigation often collapses under the weight of delay, confidentiality, and PR gamesmanship. Who needs reforms that protect due process while preventing procedural hide and seek? The book's service avoidance allegation should promote a sober review of cross-border service in civil abuse cases. The title removal debates should be principled, general, and statutory, not ad hoc. Parliament can legislate for further cases with clear criteria and independent triggers so that symbolic sanctions are not purely theatrical. And Giuffre earmarked settlement funds for survivor support through her foundation work. Whatever one thinks of her specific claims against Andrew, the policy need is obvious: prosecution, protection, and prevention. The state and the sector should match that triad without money, or with money, without excuses, and with metrics. Nobody's Girl is not a legal brief. It's a demand note addressed to power. It asks whether we are prepared to treat the vulnerable as citizens rather than reputational obstacles. It asks whether an hereditary brand can coexist with democratic accountability. And it asks sharply whether we have the stomach to keep reading when the story refuses to tidy itself away. The facts will keep moving in the days ahead, but one observation is already secure. When private vice collides with public office, euphemism is complicity. Today's publication strips away the euphemisms. What remains is a test of law, of Parliament, and of the palace.